on this episode of Whack-a-Doodle. Who knows? And who cares? Are the only answer this plaintiff provides. In other words, the judge is acting like a bully.
The horror, the scandal, the betrayal.
That they tricked us into staying.
But this is not a streetcar named Desire.
Who knew that Pennsylvania does not follow the American rule? Welcome to Whack-a-Doodle. Today we're going to talk about another case with Michelle and Christopher Page. So if you're trying to put this case into the Page Cinematic Universe timeline, this is going to be 2016, which is before we get any of this Dragon Curve, Di-Fi, Ethan Eden stuff in the mix, but it's going to be after the Lerner Fund case, or the case, and after they've declared bankruptcy. Disclaimer to start off, I don't know anything about bankruptcy, but essentially, to summarize this case, the Pages HOA is suing them because they didn't pay the HOA fees. And the Pages are once again acting as technically pro se. And one final note, I'm just going to put my opinion out there to begin with. HOAs suck. Foreclosure sucks. Capitalism sucks. I do really feel bad for the Pages in this. They do seem to be going through a rough time that doesn't seem to be getting better even after this. But they also aren't helping themselves with their behavior. And that's what I'm going to talk about here, because I find it fascinating not to make fun of someone who's going through a hard time. So let's get into it. Chapter 1. Uninvited. As I mentioned in this little summary, in 2011, the Pages filed for bankruptcy, probably because of the hedge fund company not working out and the Lerner Fund case, they lost that, so all their money was gone. They also stopped paying their HOA fees, and their house was foreclosed on at this time. However, they admitted in the filings that they continued to live in the house at that time. There is a 5-year gap here between August 2011, which is the bankruptcy, in May 2016, when the HOA filed a civil suit for these overdue fees. And then a month later, June 2016, the house was sold at a foreclosure sale. According to the Pages, they do not owe HOA fees. And their arguments for that are, in their little court filing documents, they say that they didn't technically own the home because they had declared bankruptcy. So they shouldn't have to pay the HOA fees because, the bank or the mortgage lender own the home, so they should pay the fees. The Pages also say that the HOA waited those 5 years to collect these fees or to sue them for the fees. So it's reasonable to infer that the HOA had gifted the Pages 5 years of service and should have no expectation of repayment. Chris Page says, "It is inequitable and unconscionable to allow them to force us to pay for services we didn't want or need and that were provided with no realistic anticipation of repayment in order to benefit and protect their own properties and values thereof. They could have pursued actions against our estate and or the home's new owner. They simply chose to sue the people who could not pay, which is wasteful and unreasonable." So once again, the argument of they don't have any money, so there's no reason to sue them. Classic lawyer argument, honestly. They say that suing a judgment-proof defendant is useless and wasteful. Here, the HOA chose to run up their legal expenses seeking an uncollectible judgment. Neither law nor equity permits parties to impose the costs of such futility upon others. Besides, they lost in federal court already, so we shouldn't have to pay for their unsuccessful litigation against us. So when they say lost in federal court, I'm pretty sure this is referring to the bankruptcy part of the Lerner Fund case, where the Lerner Fund alleged that they were hiding money and just pretending to be bankrupt and not have any money. And the judge didn't find that the Pages were hiding money anywhere, and so that the bankruptcy could go forth. So I think that's what this is. I don't know how much the HOA is actually involved in being part of the Lerner Fund suit, being part of the foreclosure stuff. It seems like those would be different companies, but whatever. Who knows with how hyperbolic these communications are. It's really hard to know what they're talking about. They also say Sadly, my family and I are victims of one creditor's unlawful vendetta. A vendetta that appears likely to force our bankruptcy into its 6th year! Exclamation point. Also an interesting plea for sympathy for the family and like bringing the family involved this time. My family and I are victims. There's simply no theory of law or equity that allows this creditor to add to our family's misfortunes. The home at issue is gone. The legislature did not intend to squander scarce judicial resources debating whether or not they have a claim upon our non-existent, non-exempt assets. So after that, they respectfully, quote unquote, request a jury. And I will say this letter is more respectful than a lot of the others we've seen. But, dear listener, will it remain that way? So continuing on in 2016, the pages file some more motions and answers and replies and corrections and whatever. A lot of them are filed incorrectly, or they're late, or they're in the wrong order, or they're called the wrong thing, or they submitted the wrong things at the wrong time. But in response, the court says, the defendants are pro se and clearly attempting to raise issues within the rules of civil procedure, but without legal training, they are doing so improperly. Which, like, God, they have legal training. They both have law degrees from Yale. What do you mean? What do you mean? I guess this judge, like, didn't look that far into it. Didn't look into it as much as I have, I guess. Which is fine. Which is totally fine. I'm just, like, crazy. As a solution, the judge recommends that they get legal counsel, which is fair enough, but, like, it's tough. When you just filed for bankruptcy and you don't have any money, what are you supposed to do? There are resources out there to kind of help, but in civil cases, you don't have a right to a public defender. Like in criminal cases, they'll give you a lawyer even if you don't have one. That's not the same in civil cases. So I can definitely see how like these big companies with these really expensive trained lawyers can just walk all over general people who don't have any training. And if they don't have any money to hire a lawyer to defend themselves, then like they can just lose and lose and lose. So for this case, the judge decide that he'll just make the decision himself. He says no jury trial, no oral arguments from the parties. He's just gonna do a summary judgment himself. This is what the HOA wanted. This is not what the pages wanted. This is how the judge decided, or the judge's explanation, the judge's rationale for doing a summary judgment instead of having like a jury trial. The judge said that the pages actually admitted to all of the HOA's facts that they presented, which were 1, they knew that there were HOA fees that were due, and 2, that the HOA did do some kind of regular maintenance, shared services. The court also said that based on the bankruptcy code, the pages were still the owners of the house, even after the foreclosure, and that they still were required to pay the HOA fees. And in fact, it looks like based on the law that the judge put in there, like, yeah, it says HOA fees aren't included in like the bankruptcy. You still have to pay them. There's some things that you just kind of can reset and some things you can't just reset, and HOA fees are something that you would still have to pay. So the court ruled that there's nothing that the HOA says that the pages disagree with, and they said it's a waste of the parties and judicial resources to enter into discovery and to extend litigation if both parties agree to the same facts from the beginning. Yeah, so he says it's just a waste of time. They're not even going to do discovery, which is like where you ask the different parties for like, well, give me your cell phone records, well, give me your bank statements or whatever. The judge is like, no, it's all here. It's fine. We don't need to do any more looking. We already know that the pages are the HOA. The judge also says that the pages' alleged defenses are a jumble of legal theories and contradictory what-if scenarios. They have failed to plead specific facts or attach documentation which might support any of their arguments. It appears they have essentially thrown out a number of legal theories and possible scenarios in the hope that one would stick. The problems with their pleadings are not simply procedural, they are factual. Therefore, the court does not believe it would be necessary or beneficial to let the pages amend their answer. It would only unnecessarily drag out this litigation. Which I think is really interesting because if you'll recall from the previous episodes, Chris Page said he won an award for brief writing. And now they're saying the defenses suck. And the whole, like, the briefs and the communications suck. And that it's because they're pro se and they don't know any better. But Chris Page won an award for doing this. So I don't understand what's going on here. But anyway. Also to note here, as far as I can tell, the judge didn't actually make an official decision or give an order on the case yet. He just said that they're not going to have a jury trial and they're not going to have discovery. He's just going to look at all the stuff that was given and make a decision by himself later. So the Pages send a reply, and they once again insist on having a jury trial. There are some real zingers in this communication, saying things like, why are they allowed to sue us, a former owner, for services they allegedly provided to the new owner? Who knows? And who cares? Are the only answer this plaintiff provides. Really? How could Pennsylvania law trump federal bankruptcy law? That's a novel argument, to say the least. I realize my opponent is not a bankruptcy practitioner, but everyone knows that a bankruptcy petition automatically divests the petitioners of all title to all of their property. Which, I mean, I didn't know that, but that's all right. I don't know if everybody knows, because I don't know. So then we get into some alleged comedy, with Page saying, laughably, my opponent can't keep his story straight. Laughably, the plaintiff now asserts that our liability arises from our use of the home, rather than our ownership thereof. Funny, that's not what they pled. Laughably, they previously begged the bankruptcy court to hear testimony on this issue, precisely because they used to believe that they had to prove their allegations. But now, apparently, they believe that the truth or falsity of their allegations doesn't matter. I guess they've decided that equity doesn't actually require plaintiffs to prove that they did anything for the money they're demanding. They're getting very worked up here, and the sarcasm continues, where they say, who knew that Pennsylvania does not follow the American rule? And rule is capitalized. They also say, wouldn't it be wonderful if our legal system had invented a mechanism to force plaintiffs to explain why their statements to this court do not match their prior written statements? Oh wait, it did. It's called a trial. Boom. Mic drop. Just kidding. They keep going. They do not ever stop. There is never a mic drop because they're never letting go of the microphone. Forgive my sarcasm, because I understand but cannot condone my opponent's frustration. To all the lawyers out there, is it normal to call them your opponent and not like the plaintiff or like opposing counsel? This is like weird to me. I don't know. So once again, we get into the topic, the very familiar topic of them having no money, with quotes such as, you can't draw blood from a stone. Their desire to sue us can't change the fact that we have no non-exempt assets. The court is not a debating society that opines on moot points. If they knew we couldn't pay, then anything they gave us was a gift. That's an interesting conclusion. Another point of argument, the Pages say that the HOA maintained the home out of their own self-interest and not to help the Pages. And that's because, like, if the one house in the subdivision was like a mess, it would make everybody else's property values go down. So they said that's why they kind of did these community services and took care of the house. So the Pages said that essentially the HOA volunteered their services to protect their home values, not to assist us in any way. The Pages also allege that some of these common benefits that the HOA fees are supposed to pay for, the HOA only kind of did some of them. They didn't do all of them. So they say, we allege that they excluded us from the common benefits as much as possible. Sometimes that exclusion was petty, like failing to invite us to the homeowners' parties they now expect us to help pay for.
No, not uninvited from the HOA parties. The horror, the scandal, the betrayal.
Also, going to an HOA party sounds like a form of torture to me. The ninth circle of hell is actually just an upper middle class HOA party. I think Dante got that one wrong. We're gonna have to fix it. Anyway, they continue on. It's not just about the party, you guys. Sometimes that exclusion was serious, like failing to shovel our sidewalks or allowing rats and water to enter our home. Rats and water be like, "Hey, can we crash here for a while?" HOA be like, "Yeah, sure, why not? They're not using it right now. Come on in." Then we get into some real hard-hitting rhetorical questions. Quote, "Don't those exclusions tell you their real purpose and design in this case? Isn't it clear that they were helping themselves, not us? Is it an accident that they chose to sue the parties who could not afford legal counsel to defend themselves? Isn't it curious that they finally filed their lawsuit after they learned that we had prevailed in the bankruptcy litigation? After their other claims had been dismissed as ludicrous and utterly lacking in evidentiary support?" So I think, again, this is talking about the Lerner Fund bankruptcy dismissal. I didn't see anything about it being ludicrous, just that there wasn't enough evidence. Maybe I missed it. But from my reading of the papers and the orders, the judge just says they can't find any evidence of it. Not that it was, like, stupid or ludicrous. Anyway, okay, we gotta stop joking for a second. We gotta be serious because, sadly, the HOA's actions helped force a hasty and untimely move, which led directly to the death of Graham, my wife's 95-year-old grandmother. First of all, poor Graham. It's really sad, and I don't want to diminish the impact of someone dying in any way whatsoever. I am confused, though. I'm a little bit confused because they did have 5 years to move, first of all, so I'm not totally sure why it was hasty. And secondly, I don't know how it was the HOA's fault that they had to move. I thought it was the foreclosure, which is a whole other case. And they also said they weren't living there full time. They seem to already have somewhere else to live if they weren't living here full time. But also, I will say, moving is very stressful, so maybe it is true. Maybe the stress was just a little bit too much. I'm just not sure we can conclude that the HOA killed her. They also question, why did the HOA have to file suit at the precise moment that Graham's health made us particularly vulnerable? Was the timing of their actions coincidence or strategy? So now they're going all in on accusations. Like, the HOA is like sitting in the dark in a meeting room with cloaks, wringing their hands. Like, yes, we shall wait until Monday to serve the notice, for Graham is in poor condition, and it will surely weigh in our favor if she simply cannot withstand the stress of the move. Yes, for the greater good. In all seriousness, I do feel bad for them. Moving on, they say, a reasonable juror could infer that they tricked us into staying. And this is because the HOA allegedly said that they would wait for after the bankruptcy case to be over before they collected fees. They also say, lots of people make money-losing decisions every day. They don't get to sue someone else for their losses, particularly when that person can't pay. Anyway, this request for a trial and oral argument and jury was denied by the judge. So then the pages send notice of an appeal. Then weirdly, the HOA requests that they permit oral arguments, but not have a jury trial, just that there's oral arguments to respond to some of these interim filings from the pages. I have no idea why. Maybe it's to stop all of these extra motions and filings and answers and things that the pages keep like shooting out. But the pages respond. To be clear, I have nothing against either opposing counsel or his client, but civil procedure exists for a reason. To ensure justice. Okay, Batman. They also say, we simply cannot participate in oral arguments. We cannot afford to make an additional trip to the court, and we have no one to take care of our children and or our elderly aunt, who suffers from dementia-induced schizophrenia. I try to cut out as much as possible for like the details of their family and their illnesses and all this other stuff. Which, like, Jesus Christ, y'all, they got a lot going on. Anyway, I have no idea why both of the parties changed their minds now, but regardless, we're about to go on another detour in the proceedings. Chapter 2. The Page and the Pauper. So at some point during all these proceedings, the Pages submitted an in forma pauperis, which essentially means that they don't have the money to pay the filing fees. This form was declined by the judge without really any explanation. And I don't really understand that. Like, the Pages did declare bankruptcy and had a whole trial about it, so the court did kind of rule that they don't have any money. But anyway, the Pages also submitted an appeal for the decision not to have a jury trial. But because they didn't pay the fees and the in forma pauperis was denied, their forms didn't get sent to the Superior Appeal Court. So they want to appeal this pauper form, but it's kind of like a catch-22. They didn't pay the fee, so the court won't send the appeal, but without the appeal, the court can't rule on whether or not they should pay the fee. So it does kind of suck. But also to note, the filing fees were like $50 and $100. So I'm sure some people can't afford that. I'm just giving you the full picture. It's not like $1 million fees. So they were stuck in kind of this catch-22. So their next step was to petition for a writ of mandamus. So these writs are usually used in situations where a government official has failed to act as legally required or has taken a legally prohibited action. So essentially it's a letter to the higher court to make the lower court do something. And in this instance, the Pages want the judge to hold an evidentiary hearing to explain why he denied waiving their filing fees. And just to note, in case you're getting a little bit lost here, this isn't even about the jury trial decision. This is about filing fees. So then they can send the appeal to try to get a jury trial, to try to get a verdict. So we are like so far off from the actual end of the case. The final verdict isn't even close. These writs seem like a big deal to me. Like, it's kind of a serious step, but maybe not. Maybe I'm just misinterpreting. I can see how they were kind of stuck here with being unable to make an appeal and then unable to pay and then unable to appeal their ability to pay. But this letter to the higher court does get a bit heated, so we have some quotes here. As if the judge seeks to display his complete and utter contempt for this court, our legal rights, and his legal duties. The judge took 3 business days to mail his decision to us, but only 1 business day to reject our petition. How can he possibly justify his decision to take more time to drop his decision in the mail than he took to reach that decision? Damningly, the respondent took time to rewrite our proposed order to omit any assertion that he had read or even seen our petition, including our affidavit of poverty. Does anyone think that's an accident? Jumping in to say there's a lot of exclamation marks in here. I don't see what they're talking about rewriting proposed order, but maybe it's something that wasn't part of the court documents. Maybe it was just something they sent them. I don't know. Getting back in the letter. In other words, the judge is acting like a bully, not a judge, by seeking to block our appeal by any means necessary. Judges aren't supposed to have a personal stake in the litigations they're adjudicating, and they're not supposed to act like they have a stake either. At best, his actions are unprofessional. At worst, his actions are blatantly unethical. This is also like another weird tone shift in the middle of this quote. Continuing on. How can anyone trust this judge's actions in this case when he ignored authorities that I was able to locate in a few moments using only Google? Surely a judge has greater knowledge of the law than what the village idiot like me can locate on the internet. Dude, you're a lawyer. You have a law degree from Yale. Let's not pretend. In lay terms, what did the judge discover in less than 2 business days that the federal plaintiff couldn't find after more than 5 years of litigation and tens of millions in legal fees? So I just put these in there, by the way. You can't tell with me talking,
but all of these have the number spelled out and then in parentheses. So I'm sure it's standard for these documents, but it just reads so funny to me with these kind of snarky rhetorical questions, because it reads like, what did the judge discover in less than two business days that the federal plaintiff couldn't find after more than five years and tens of millions in legal fees? That's how my brain reads it, and I just think it's funny. Anyway, moving on. If that's acceptable jurisprudence, you might as well close up shop and go home, because you're not doing anything of value if you're just taking the inferior court's word for it. How do you even know that he exercised discretion? How do you know that he's not discriminating against us? How do you know he's not shaking us down for bribes? It's not like there's never been a corrupt judge in this Commonwealth. There are allegedly a lot of corrupt judges in the Northeast, according to the pages, so that's interesting. We see no reason to belabor the obvious. And then they go on for a few more pages of writing. So I don't know, that's true. Once again, either the pages are out of order, or some were deleted, or they were lost or deleted for privacy and confidentiality. I don't know. But we can move on. Literally, he's simply asking you to assume that he's right. But this is not a streetcar named Desire, and we are not required to rely upon the kindness of strangers. And this sentence just reminded me of an ex of mine who said that all lawyers thought that they could be or wanted to be writers. This whole situation makes a lot more sense now that I've remembered that. But I actually think Chris Page would be good at it. I read what he wrote. I mean, I am right now. In the end, the pages did get what they wanted. So the original judge changed the ruling and allowed the pages to proceed without the filing fees, quote, in the interest of judicial economy, which to me means he's saying like, oh my God, let's just get this over with already. And then about a month later, after everything was resolved with these filing fees, the higher court responded and said that they can't rule on the writ, but they should be able to see the appeal. Meaning the jury trial appeal. So with this out of the way, we can get back to the actual issue at hand, which was paying the HOA fees. Chapter 3. Viva la Revival. Now that all of the filing fee discussion is over, we are back to the case. The pages send a reply to the reply to a reply. I think they're still asking for the jury trial. It's all very unclear to me. It just seems like they're angry. This letter starts with, please understand that I am a novice. A novice that won an award for brief writing at Yale Law? I don't know about that. But to their credit, this reply is overall more structured, and there's less like nonsense within it. It has a very specific like question and answer format that the HOA used in their document. So this seems to be more official. He still goes in though and doesn't shy away from the rhetorical questions. He says, should the trial court have ignored the legislative history? Should the trial court have ignored the fact that Congress required bankrupts to elect whether they keep their home after bankruptcy? Was the trial court correct when it assumed that Congress secretly intended that the election to keep their homes to be a meaningless nullity? I'm also very confused about what role the HOA can play in a foreclosure. According to the internet, the HOA can foreclose in order to pay a debt. But based on the foreclosure filings in this case, it looks like it was the bank/mortgage lender and not the HOA. So I don't really know what they're talking about here. We move on. Was the trial court correct when it engaged in ex parte communication with opposing counsel? So ex parte communication is when a judge discusses the case with one party without the full set of lawyers and plaintiffs and defendants being present, and it is generally illegal. I don't know what he's referring to here. He does talk about a reply brief from the HOA, so maybe that's it. It doesn't seem like they were having like secret meetings where they talked about how to screw over the pages or anything like that. He also says, neither law nor equity permits this court to shift such burdens to paupers, particularly where, as here, The resulting discussion is a practical nullity. And I only included this because this is such a classic Christopher Page sentence, and I love it. So the judge responds to the above communication and says the court addressed all these in their previous order. So basically like, nah. So a few months later, the higher court denied their appeal for the jury trial request. And then finally in 2017, we have a ruling for the case. The Pages are required to pay back the HOA fees, interest, and pay the attorney's fees. The court notes that the argument portion of the Pages brief poses a litany of rhetorical and hypothetical questions, along with undeveloped arguments that invite this court to rule in their favor out of sympathy for their financial situation. The court also says that their arguments were so inadequate, the court can't even review and respond to some of them. So it looked like the amount that the Pages owed the HOA was about $40,000, and this was all finished up and decided in 2018. Or was it? At the end of January in 2023, so that's about 5 years later, the HOA issued a writ of revival saying that the Pages still hadn't paid this amount. Then in February of 2023, the Pages reply and say that it was already settled, and they provided a copy of the check as evidence. The check in this reply is less than the original amount. It's about $28,000, but it does look like they had previously agreed to settle to this lower amount. But because of the writ of revival, the Pages kind of go in and say the HOA seeks a substantially lower amount than it previously demanded. Either the HOA knows the right amount and they attempted to defraud us for a larger amount, or they don't know the right amount and this court will need to adjudicate this dispute. They also say the court doesn't have jurisdiction, that this isn't the right place to settle on the amount, that they still want a jury trial, and they're trying to get the HOA's lawyer off the case, saying that he had a conflict of interest now, etc., etc. Essentially, they seem to be threatening to extend out the litigation if the HOA keeps complaining to them. I would say that the HOA was confused or is maybe bullying the Pages or is trying to get, the rest of the $40,000 amount. But if you look at the date on the check that the Pages sent through as evidence, it's dated February 8th. And if you'll remember, the writ of revival was at the end of January. So it looks like they stalled and sent it after they got that writ of revival at the end of January, and then finally paid it and basically sent a letter saying, leave us alone, it's done. So with this, the case does look like it's finally over. As a reminder, the bankruptcy started in 2011, the HOA case started in 2016, and the fees were finally paid in 2023. So in conclusion, capitalism sucks, man. I'll catch you later.
The views expressed in this podcast are solely those of the host. The podcast is intended for general information and entertainment purposes only. The content provided is based on publicly available records. The podcast, host, and creators make no accusations, implications, or charges of any crime, wrongdoing, or unethical behavior whatsoever. The host has little to no knowledge of justice system norms, and any opinions stated are for the purposes of humor only. Please do not contact anyone mentioned in the podcast.